Mhm. You know, I've sent you copies of the state constitution, the Fifth and the 14th Amendment. Then there are these other sections: political power, yeah, supreme law of the land, yes, that would be the United States Constitution, yeah, personal rights, no person shall be deprived of life, liberty, or property, yes, without due process of law, Section 3. Yeah. Now, liberty, as defined in that screen print I was reading, yes, is the removal of all restraints so that I can enjoy my liberty. Now, of course, you're getting sued for Section 1. Yeah. That you, the government, had decided that your powers, yes, were not from the consent, no, and you decided to violate the individual rights of myself, yeah, my sons, yes, and then there's Marilyn and her kids, yes. Now, of course, you're getting sued for Section 1, yes. Then there's Section 2, ooch. That would be the Fifth, the 14th Amendment, yes. In fact, approximately, some of them multiple times, but I think about 23 or 24 of the different amendments, yes. And then this idea that you cannot deprive a resident of the state of Washington, yes, of life, liberty, or property without due process of law. Now, within the confines of due process, yes, is what's known as the durable power of attorney right now. You're getting sued for that one, yes. Now, the people who assemble common good shall never be abridged. Yeah. Freedom of speech. Every person may freely speak, write, and publish on all subjects. Being responsible for that abuse of that right. Yeah. Oaths. Yes. The mode of administering. Invasion of private affairs or home prohibited. Obviously, well, you're getting sued for number 6, number 5, and number 7. Then section number 8, irrevocable privilege, franchise, or immunity prohibited. No law grants the irrevocability of any privilege, franchise, or immunity shall be passed by the legislature. Now, a lot of judges in the state of Washington, they thought they were immune from prosecution. Yes, they did. They thought they had a privilege as a Superior Court judge, yes, to refuse to remove the restraint provisions of my individual liberty, yes, because of the use of forgery, fraud, felony, yes. And then there's that abuse, yes, of the moral turpitude, of the contempt of court, of the durable power of attorney, of the individual known as the petitioner. Now, since I didn't get any notice of court hearings, yes, you didn't, I'm going to sue this state right now. Irrevocable privilege, yes, franchise or immunity. There's the rights of the accused person, against himself will be twice put in jeopardy for the same offense. Yes. And then there's the administration of justice. Justice in all cases shall be administered openly and without unnecessary delay. Yes. You're getting sued for that one. And then section number 11, you're getting sued for. Yes. Section number 12. No law should be passed granting to any citizen, class of citizens, or corporation other than municipal privileges or immunities. Well, as judges, you're getting sued for that. And then the habeas corpus, section 13. The writ of the privilege. The privilege of the writ of habeas corpus shall not be suspended. Mhm. Unless in case of rebellion or invasion, the public safety requires it. Yes. Judge Landis, yeah, and Judge Porter are getting sued for section number 14. Yes. It is excessive bail, fines, and punishment. Yes. To obligate an individual to go to jail for 27 days. Yes. Because the Sequim Police Department falsified a traffic citation accusing me of being in Sequim at 2 different times on December 31st. Now, the $500,100 I thought was excessive, yes, but I wanted Judge Porter to know, yes, I'm suing you for that because it is excessive to put $1,000 bail, cash, $10,000 bond on a known homeless person that has communicated with law enforcement about not wanting to evade going to court. Yes, I just wanted notice. Yes, he did. Notice of the court hearing. Now let's look at Mike Van Proyen. Let's say Mike was getting all my mail and somebody had changed my address. Yes. Falsified my state issued identification. Yes. Issued a citation for my arrest on December 31st of 2015. Yes. But they didn't. The citation date was the 31st. They issued it on the 4th. They decided to wait 4 days for an individual that was accused of committing domestic twice, domestic violence twice in the same day. It's nice that you left me out there for another 4 days. Well, since I wasn't there, yes, I thought that anytime you had knowledge of domestic violence, you can't have a citation date of the 31st. Yes. And an issuance date of the 4th. Now, I would say that I'm suing you for that. Ooh, anytime that you have what you believe is probable cause that an individual has been involved in domestic violence, your citation date and your issuance date should have been the same. Sounds like you were sitting on it the whole time right now. Now, fines and punishment. Yes. Excessive fines would be anything really. Yes. And then there are those fraudulent mental health evaluations that were cruel. To say that I was bipolar, schizophrenic, and delusional for knowing that I wasn't in Sequim, I was in Jefferson County. Now, no conviction shall work corruption of blood nor forfeiture of estate. Yes. But it looked like you were going to forfeit my estate. Yes. See, your mental health evaluations where you found me incompetent to stand trial, yes, they were an actual judgment. And since you could have involuntarily admitted me into a mental institution where my my competency to manage my own estate would have been taken from the state, yes, Joel's Law. This whole idea of convicting an individual of incompetence, yes, for the refusal to admit the evidence that I wasn't in Sequim and I wasn't in Jefferson County, yes, does cause a forfeiture of the estate of the incompetent. Now I'm going to sue you for that one. Yes, he is. Yes, he is. See, we have this problem. Yes, we do. The individual known as the state, yes, as the plaintiff, has an obligation for the enforcement of their individual constitution. Now, I was told that I was charged with violating a protection order. Yes. And to convict me, you had to prove, yes, that there existed a protection order. You didn't have to prove that Heidi Budnick had actual jurisdiction of court to motion the court. No. You didn't have to prove there was a stipulation in order. No. You didn't have to prove there was an expungement of the actual arrest in court record. No. All you had to do was to allow the indigent pro se petitioner to motion the court without any actual due process to myself.